as the court cases.
So what did he say, Mrs. Okon?
My lord, he said that he's trying to link up, that if he cannot, the court can proceed and read the judgment.
Okay. So I'll call the case.
All right, my lord. He's around. My lord is around.
He's around. I've not seen him. Maybe he has muted his video.
Okay. My lord, we can proceed.
Okay, call the case.
Okay. Resume today at Uyo, Thursday, 8th December 2022, before His Lordship, Honorable Justice M.A. Namtari presiding. Suit number NICN UY 14 2019 between Reverend Samuel David Iwan and Registered Trustee of the Lutheran Church of Nigeria, National President, Lutheran Church of Nigeria. All of the parties are absent.
Appearance.
My lord, my name is Idigbe. My lord, my appearance is for the claimant. So I apologize for the absence of the claimant.
Yes.
With profound respect, my lord, Anthony Idigbe Asukwo. Anthony Idigbe Asukwo. My appearance is for the defendant.
Anthony Ekpo Asuko.
Idigbe, EKPE. Idigbe, EKPE, Lord.
EKPE.
Anthony Idigbe.
Okay. Today is for judgment, right?
Yes, my lord.
Good. Let me, as usual, I have for representation Edidion Ekon for the claimant. Correct?
Yes, my lord. Correct.
Anthony Ekpe Asuko for the defendants.
Yes, my lord.
But I also have Francis Ekenem for the defendants.
Yes, my lord. Francis Kanem and Anthony Idigbe Asukwo are in the same office. They represent the defendants, my lord.
And who conducted this case?
Oh, my lord, it was hand in hand, but we can say it Francis Kanem with Anthony Idigbe Asukwo.
Okay. Fair enough. Okay. That is stage one. Please, can I seek your permission to go straight? Who is this?
Apologize, my lord. My lord, this is a public city. I do not know who that is.
Oh,
it's the representative of the defendants. I don't know why he's not dressed, knowing he's in court, sir. You're actually in court. You're not supposed to be like this. I apologize for that, my lord.
okay. Can I take your permission to? Can I get your permission to go straight to my decision? To
Yes,
my
my lord. Yes, my lord.
As the court cases.
Okay. I can't hear you.
Hello, we are agreed, my lord, to go straight to the judge.
Thank you. Let me go straight to my judgment. I've digested the fact of this case as given in the various processes, carefully watched the demeanor of the witnesses and evaluated their evidence as it were. And I think the justice of this case demands that I adopt issue 1 and 2 formulated by the defendant and the applicant respectively in the determination of this suit. That is issue 1. Is the second defendant a juristic person capable of being sued and therefore subject to the restriction of this court? Issue 2, whether from the facts of and circumstance of this case, the claimant has established his case to be entitled to his release. Issue 1, this issue by the defendants hinge on the fact that the second defendant is just an office in the first defendant, and therefore not a juristic person who can sue and be sued. The claimant, however, posited that a party can be sued in his official title, as in this case, National President of Lutheran Church, and that it is the Constitution of the Lutheran Church of Nigeria, 1990, that provided for the juristic personality of the second defendant as the president. Now, as a general rule, only natural person that is human beings or juristic or artificial person, such as a corporate body, are competent to sue and be sued. See the case of Lake Medical and Bitweiser and Atuba and Gura. The law recognizes some exception to this, such as where the legal capacity is given by the rule of court, common law, or statute, expressly or impliedly. Since the claimant did not bring the second defendant within any of these exceptions, I have no hesitation in finding and holding that the second defendant cannot be sued in this case. I so hold. The end result is that the issue is resolved in favor of the defendant, and the second defendant is here. The name of the second defendant is hereby struck out from this suit on the authority of Aladele Ojogbede and another Basel Corporate Affairs Commission, SOPRA. This takes me to issue 2. Whether from the facts and circumstances of this case, the claimant had established his case to be entitled to the reliefs. The case of the claimant is predicated on the claim that his purported dismissal is unlawful, illegal, unconstitutional, null and void, and of no effect. In the determination of this, I'll be most guided at all times by the dictates of the Supreme Court in the long line of cases such as Cato and CBN, Ibama and SPDC, Zidel and RSCRC. The underlying principles in all these cases and many more is that the employee seeking declaration that his termination or dismissal is a nullity must lead and prove the following material facts. A, the nature of the employment. B, the condition of service. Can you hear me? Hello? Hello?
Yes, my lord, we can hear you.
But I can't see you anymore.
My lord, my friend is here.
C, the circumstances under which the appointment can be terminated.
Yeah, fine.
Counsel, you are in court.
No, my lord, I apologize for that.
I intend to analyze the pleadings and evidence in this case in the light of the material facts A and to C above, and will only refer to the argument of the parties where necessary.
As
The nature of the employment in the instant case is undoubtedly not one with statutory flavor, but rooted in master and servant. It goes without saying, all the incidents of master and servant or private employment are not only available, but cognizable depending on proof. In any event, whether an employment with statutory flavor or under common law principles of master and servant, or employment at the pleasure of the employer, the fact of the employment and the terms and conditions of same must not only be pleaded, but must be proved by evidence before determination of the validity or otherwise of the dismissal. And this is the case of RG and Chad Basin. On the issue of condition of service, it is tried law that a servant who complains that his employment has been wrongfully brought to an end must found his claim on the contract of service and show in what manner the wrong was done. He must plead and prove condition of service, which is the bedrock of his case. It is not the duty of the employer as a defendant to prove that the determination was not wrongful. I cited Amodu and Amade, Kato and Central Bank, Okomo Oil and Eshiri Nihin, Odimboye Obo and Oba and NMPC and others. In other words, the employee has the honors of placing before the court the terms of the contract of employment before proceeding to prove the manner the said terms were agreed by the employer. In the case of Bukar Madu Aji and Chad Basin Authority, the Supreme Court is stressing the importance of condition of service in proof of wrongful termination or dismissal held, and I quote, a plaintiff who complains that his employment has been wrongfully terminated is enjoined by law, and he has the honors to place before the court the terms of his contract of employment and then go on to prove in what manner the terms were agreed by the employer. Where he fails on both counts, his case will have no legs to stand. In principle, it is not for the employer who is a defendant to an action brought by the employee to prove any of these issues. In the instance case, the appellant did not place or prove the terms of his employment with the respondent, and so his case has no legs to stand on. End of quote. The condition of service regulating the employment relationship of the parties in the instant case is a subject of intense debate. It will also be noted that the claimant did not tender a letter of employment evidencing the condition of service. Because the onus is on the claimant to prove the condition of service, I start with his position. To the claimant, Exhibits CW 13 and 14 contains terms of contract of employment between the defendants and the claimant. These are the registered constitution of the Lutheran Church of Nigeria and the condition of service effective January 1994, respectively. By Article XA sub 6 of the Exhibit 13 to show the LCN officers and other let me take that again. The claimant relied on Article XA6 of Exhibit 13 to show the LCN officers and other officers as specified in the bylaws are applicable to the claimant. Similarly, by Article XA6, the officers of the district are district superintendent appointed by the president of the LCN to serve as his liaison officer to a given district, and the claimant is one of such superintendents. As for Exhibit 14, the claimant relied on its general provisions to the effect that regulations may be referred to as the condition of service for all categories of the first defendant staff or its agencies, namely short office, EML seminary, Lutheran printing press, Lutheran children's home, and Lutheran health centers. From the above, Exhibit 14 is applicable to all staff of the Lutheran Church of Nigeria, including the claimant. To show in what ways Exhibit CW 13 and 14 were violated by the defendant in the process leading to the dismissal, the claimant relied on Article 31 of the approved condition of service, that is Exhibit 14. By Article 31, it is mandatory that membership of the disciplinary committee of the first defendant shall be 5 to form a quorum. But from the report of the committee, who decided the fate of the claimant, only 4 members were present. In the same vein, Article 14, Roman 4, sub 2b of Exhibit CW 13, which provided that for any officer to be removed, the board of directors must do so by a vote of 2/3 majority of his membership, was not complied with in the removal of the claimant. Also not complied with was that all disciplinary action against an officer must be sanctioned by the council of the first defender. This also explains why the board of directors, instead of approving recommendation of the disciplinary committee for the suspension of the claimant for a period of 1 year without pay, went ahead to dismiss the claimant. On the part of the defendant, it was contended that the claimant has not presented any letter of employment which would have stated the terms and conditions of his employment. To the defendant, the relationship of the claimant with the first defendant is spiritual and not contractual. So the provisions relating to discipline and removal of in the Constitution, that is that Exhibit CW 13, are not applicable to officers and members of the church. Let me take that again. Exhibit CW 13 are only applicable to officers and members of the church and not ministers serving in various congregations, like the claimant. It is the explanation of the defendant that Article 13 of Exhibit 13 provides for the expulsion of a member from the synod, and as undisputed member of the Lutheran Church of Nigeria, the claimant was not expelled as a member, but dismissed as a minister of the church. As for the condition of service, that is Exhibit CW 14, it deals with the appointment, promotion, discipline, and retirement of permanent staff of the central administration of the church and its institutions, specifically listed therein, not ministers serving in congregation of the church such as the claimant. The claimant cannot therefore rely on Exhibit CW 13 and 14 to sustain the claim. Now, I've taken a hard look at these 2 exhibits. Exhibit Article 6 of Exhibit CW 13 has listed 8 conditions for acquiring and holding membership of the first defender. Condition 7 is of particular interest to me. It is to the effect that congregation and individuals shall be received into the membership at such a time and manner and according to such procedures as shall be set forth in the bylaw to the Constitution. There is no indication that the claimant or his congregation has been so received or any such procedure to that end has been embarked upon in this case. Similarly, Article XA of Exhibit 13 listed officers of the first defendant as president, vice president, secretary, treasurer, registered trustees, and other officers as specified in the bylaws without even a mention of the minister serving in congregation like the claimant. Exhibit CW14, which is the approved condition of service, is not without its implications. To start with, the general provision stipulated that the condition of service for all categories of first defendant staff or its agencies, and went ahead to name them as Synod Office, GEML Seminary, Lutheran Printing Press, Lutheran Children's Home, and Lutheran Health Centers without a mention of congregation or parish. By the validity of the appointment on page 6 of Exhibit CW14, and an offer of appointment, whether permanent or temporary, shall be in writing under the hand of the secretary of the first defendant. There is no such offer letter for the claimant here. There is also meat in the contention of the defendant that the last 4 pages of Exhibit CW14 lists the categories of employees of the first defendant to which the exhibit apply, and no mention is made of the minister permanently serving in congregation of the church like the claimant. With this, and coupled with Exhibit CW1 and 3, it is easy for the court to agree with the postulations of the defendant that Exhibit CW13 and 14 are not available for the claimant to sustain his claim that his dismissal was wrongful. Exhibit CW1 and 3 are official placement and transfer notice for ministers of Lutheran Church appointing the claimant to take charge of pastoral services in Ekot Akudo and Ekot Obia Ofong, respectively. These 2 exhibits not only give the claimant job description in the congregation or parish, but completely place the responsibility of the payment of the claimant's salary and other allowances squarely on the congregation and the parish. So all the effort by the claimant to bring the claimant within the disciplinary procedure under Exhibit CW13 and 14 are too far-fetched and too far removed to change the trajectory. Next is the circumstance under which appointment can be terminated. Generally, the onus is on the claimant to prove that the determination of his employment is unlawful, null and void. But where, as in this case, the employer gives a reason for dismissal of the claimant, the law imposes on him the duty to establish the reason to the satisfaction of the court. See the cases of Shell and Olariwaju, Institute of Health and Kanyip, where Justice C.M. Tukumaene put it succinctly thus, and I quote, although it is tried that an employer is not obliged to give reasons for firing his servant at all the same, it is settled law that where he has provided any reason at all, it is obliged to satisfactorily prove, same as the onus is on him in that regard. Otherwise, the termination / dismissal may constitute a wrongful dismissal without more. The reasons for the dismissal of the claimant can be found in Exhibit CW12 as follows, and I read. Notice of dismissal. I'm directed to communicate to you that the Board of Directors of Lutheran Church of Nigeria are meeting on September 29, 2012, was forced by you to take the painful decision of dismissing you from the LCN ministerium with effect from 1st October 2012. The action of the board was predicated upon the report of the disciplinary committee of the church on how you dare to run a parallel office with that of the national president and stroke archbishop of the church, as evident in your announcement of the reinstatement of the church council, which the bishops have dissolved. The board viewed your action as an act of gross misconduct and insubordination, which is a threat to the orderliness and respectability of the ministerium of the Lutheran Church of Nigeria. You are, however, advised to collect your salary for the month of September 2012 and your pension contribution, if any, from LCN Treasury. We will continue to pray for you in Christ. Signed, Reverend Godwin Ishet, National Secretary. By this letter of dismissal, the defendant must prove gross misconduct and insubordination resulting from daring to run a parallel office with that of the national president, as evident in the announcement of the reinstatement of the dissolved church council by the national president. This allegation is predicated on what transpired during the pastoral visit of the national president to the congregation of the church in Ekot Obiang in a bid to restore peace on the 26th day of August 2012. After the worship service on that 26th August 2012, the second defendant convened a meeting of the church council elders of the Congress to resolve the difference among the members. In that meeting, a vote of no confidence was passed against the church council, after which a motion for dissolution was unanimously adopted. No sooner than the national president dissolved the council and directed the elders of the church to take control, than the claimant stood up to reinstate the council and warned the elders against taking control of the council as directed. To prove this narration, the defendants relied on the minutes of the meeting of the church on 26 August 2013, that is Exhibit CW20, which led to the dissolution of the council. There is also the letter from the national president of the church to the chairman of the disciplinary committee reporting the incidents of 26 August 2012, that is Exhibit DW4. The defendant also relied on the invitation to the church for a meeting, by the church. He relied on the invitation, to the claimant for a meeting with the disciplinary committee on the 11th September 2012, that is Exhibit CW7. And the letter of invitation / query dated 11 September 2012, Exhibit CW8, to show the action taken in the process before the claimant's dismissal. Perhaps the response of the claimant to the query, that is Exhibit CW9, is the greatest proof of the allegation against the claimant. In that exhibit, the claimant not only admitted to the allegation of announcing the reinstatement of the dissolved council, but seeking to justify it on provocation by the national president, in addition to other allegations against the national president of the church. Closely connected to this is also the report of the disciplinary committee, that is Exhibit CW11, which, among others, found that the claimant actually announced the reinstatement of the council after the announcement of his dissolution, and the failure of the claimant to show remorse as underscored by the language deployed in his response. From the foregoing, I have no hesitation in finding and holding that the defendants have proved the gross misconduct and insubordination of the claimant by countering the dissolution of the church council by the second defendant this far. Can this therefore be the end of the matter? I think not. With this finding, the evidential burden has now shifted to the claimant to prove otherwise. Now, the fulcrum of the case of the claimant is not based on the denial of the allegation, but on the procedure adopted in the dismissal. In other words, the claimant did not place any evidence to exonerate himself from this allegation, and in fact, by his letter of response to the query, that is Exhibit CW9, admitted to announcing the dissolution of the church council, giving provocation by the second defendant, and a litany of other actions committed against him by the second defendant. So as far as the allegation of the insubordination against the claimant is concerned, it has remained unchallenged. It is, however, the case of the claimant that his dismissal was a contravention of the Constitution of the Lutheran Church of Nigeria and condition of service in that he was not called to account, suspended, or his case submitted to regular counsel. Having held earlier that the Constitution of the Lutheran Church of Nigeria and condition of service, that is Exhibit CW 13 and 14, are not applicable to the claimant, this contention is of no moment. The case is therefore hereby dismissed for lacking in merit. I make no order as to cause. From all I'm saying, the claimant has failed to dislodge the allegation of gross misconduct and insubordination against him. The case of the claimant is therefore hereby dismissed for lacking in merit and proof. Judgment entered accordingly. Hello? Can you hear me?
Yes, my
Lord.
My Lord, we are grateful for my Lord's well-reasoned judgment. We are grateful,
Lord,
my
I
also
hope
grateful.
it is young. you read it and see, and maybe you'll appreciate it more.
My Lord, I think they will. They will appreciate it more. We are grateful for the well-considered judgment, my Lord.
Thank you. In the absence of any other business, the court shall rise.
As the court is
Oh.